I have the privilege of being the Dean of Gonzaga Law School, and we are very happy today to welcome Washington State Attorney General Bob Ferguson back to Spokane and to Gonzaga. He began his legal career in Spokane, where he served as a clerk for Chief Judge Nielsen of the Federal District Court in Eastern Washington. He then clerked for Judge Bright on the 8th Circuit Court of Appeals. He returned then to start practice in Seattle and joined the Preston, Gates & Ellis, now K&L Gates, one of Washington's leading law firms. In 2003, Bob Ferguson was elected to the King County Council. He became Washington's 18th Attorney General in 2012. As the state's chief legal officer, he directs 500 attorneys and 600 professional staff providing legal services to state agencies, the governor, and the legislature. As the state's chief legal officer, he is committed to protecting the people of Washington against powerful interests that do not play by the rules. He's focused on standing up for consumers and defending taxpayers, supporting law enforcement to keep our communities safe, protecting our environment, and advocating for our veterans and military families. Thus ends his official bio. On a more personal note, I can tell you that at age 9, he decided he wanted to be a Washington State chess champion, and he achieved this goal at age 18. He is now a chess master and holds an international chess rating. He is also an avid baseball fan and once took a trip to see a baseball game at every major league stadium. And until a few years ago, the only car he ever owned was a 1993 Honda Civic. But Attorney General Ferguson and his car were tragically separated when a high school student younger than the car ran a red light and totaled the car. I believe he now has a newer car, but we're not entirely sure. He is also a proud father of 9-year-old twins and a proud husband. In addition, we also know that he is an avid Zag fan because he was willing to change the time and date of his talk. But most important to the people of the state of Washington, he is passionate about being a public servant. We are appreciative of his presence today to share insights from his vocation and passion to help people achieve peace and justice in their lives. At the conclusion of Attorney General Ferguson's remarks, there will be time for questions and answers after the talk. So please hold on to them until then. I know we have some admitted students today, and we want you to realize that the discussion that may ensue is the kind of intellectual discourse and debate that is one of the very wonderful things about law school. We also know that this subject raises controversial issues, and there are a wide range of opinions on this subject. We ask that we all be respectful of those diversity of opinions. If you want to ask a question at the end, please raise your hand. Someone will bring a microphone over, and we ask that questions be limited to 2 minutes because time is limited. At the conclusion of the time for questions and answers, Attorney General Ferguson has graciously agreed to stick around for a few minutes if you want to come up and ask him a question then, or maybe have a photo taken. So, it is now my pleasure, and please join me in welcoming Attorney General Bob Ferguson.
Dean Korn, really appreciate that introduction, and the Dean and I were texting about the schedule for Gonzaga basketball leading up to yesterday's game. So as soon as it went public, we quickly realized if we went ahead with the speech yesterday at 4 o'clock, not even the Dean and I would be here. It'd be an empty. It'd be empty. And no, we're big Zags fans at my house. To give you an idea, we have 9-year-old twins, and for my 9-year-old son, his idea of a birthday present was to get in the car and drive to Spokane for the St. Mary's game this year. So we're pretty into it, as you might imagine, as a family. A couple quick things to get out of the way, and then I want to move. I've got some slides, and then we'll move to questions. As many of you know, we have the AG's office has 13 offices all around the state. one of them right here in Spokane. I used to walk past it on my way to work as a law clerk. And there are some folks here from the office. They do great work on behalf of the people. And one individual, Jason, is here. Jason, you can just stand up and wave so folks can see you. Jason Brown works in our office, and he's involved in recruitment. So for the new admittees or the law students here, if you want to talk about opportunities in our office, Jason's the guy. He'll be here afterwards as well. He can give you his contact information, but really encourage you. I know a lot of Gonzaga students work as interns in our office. I met with a number of them earlier today, and as lawyers, of course, as well. So going back to Chris Gregoire, the first woman attorney general in the state of Washington, is a Gonzaga law grad and worked in our Spokane office. So Jason's around as well. I guess this last thing, Spokane, yeah, my first job as a lawyer was here in Spokane. And so I lived in Brown's Addition and walked to the courthouse every day. And I was very lucky. Judge Nielsen, who I had breakfast with this morning, was really I was lucky as a lawyer that my first experience as a lawyer was working with Judge Nielsen. So happy to take questions later on about a career in the law as well. But one thing to think about is you choose who you work for carefully, right? It's important to have folks who, Judge Nielsen is just a very fair-minded judge, just a great human being. And I was very fortunate, I feel, to have had my start as a law career with someone of his caliber and experience. Okay, so the president's travel ban. Let's talk about it. So I'm going to talk about is, it's a big topic, right? And there's a lot there. What I'm going to try and do is give you a bit of a perspective of behind the scenes of what was going on in our office leading up to the travel ban, our thinking about it, the weekend after it was signed by the president, filing our suit, the appeal up to the Ninth Circuit, to give you a sense of, hey, you'll see pictures of some of the attorneys in the office who worked on the case. I just want to kind of give you a sense of what it was like. I'll talk a bit about the legal aspects as well. Those are complicated and numerous as you might imagine. But that's my goal, is give you a sense of what was going on in the office, the decision-making process, and frankly, what it felt like to be involved in a case of this magnitude. So let's get started. I think the first slide is, so I'm going to click this. This is during the campaign for president last year. So this is Donald Trump as a candidate. And what he's reading from is a statement from his campaign about creating a Muslim ban if he's elected president. So I think hopefully the volume will be good when I click on this. Let me get out of your way here while I do this.
Donald J. Trump is calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what the hell is going on.
So that was during the campaign, as you know. After he was elected, Rudy Giuliani went on national TV. I think this was shortly after the president was elected. He said on national TV, I'll tell you the whole history of it. So when the president first announced it, he said Muslim ban. He called me up. He said, put a commission together. Show me the right way to do it legally. How to legally create a Muslim ban, which I think is a challenge to be honest with you, right? So these are examples of statements made by the principals involved in the establishment of the executive order. And I'll talk a bit more about that. But one thing to know was the video you saw, the statements there, the statement here by Mayor Giuliani, those were literally in our complaint. Those statements and others from the administration were part of our complaint. And I will talk a bit later about why that is. As a result of the executive order, which he signed on a Friday evening, as you know, it went into effect immediately. So there were literally people on airplanes coming to the United States. It involved individuals in Iraq who had helped our military at great personal risk, were on airplanes and were turned away because this went into effect right away. And so I think this next, sorry, before I get to a video of that, here's what the executive order, there are many aspects to it. These are the parts that we were focused on in our legal challenge. So I'll tick through these pretty quickly. So first, it suspended, get out of the way here, suspended all travel from 7 Muslim majority countries, and you see those here for 90 days. Number 2, it suspended the entire U.S. refugee admission program for 120 days. It also prioritized admissions of certain individuals on the basis of religious-based persecution, had the effect of providing that the religion of the individual is a minority religion in the country would get preference. Okay, a couple more aspects. So on the refugee ban for 120 days, they suspended the entry of Syrian refugees indefinitely. And now here's a video. I just want to give you some sample. You're probably familiar with what's going on at the airports. I think this is maybe from Fox News. talking about what was going on once this was implemented by the president.
Well, Bill, because the administration did not release details of this policy beforehand, not travelers, not the airlines, not even those charged with executing the order knew what it said until it was signed. As a consequence, you have chaos here in LA as well as airports around the country and abroad. Because, hey, for instance, do we let people who were passengers with a valid visa on the flight or not? Some who arrived because they were not permitted to use their phones. People didn't know if they were here, or could they stay, or had they left.
So there were scenes like that all across the country, as you know. I have strong views on how the executive ban was created. I think it was ill-conceived. It's well documented the president did not speak with national security experts in the creation of the ban. That contributed to the chaos. What everyone thinks about as a policy, that contributed to the chaos that was going on around the country. I think I have one more. I'm going to skip this one. This is another video, but in the interest of time, I'm going to skip past this if I can. Perfect, good. So you know the scenes there, so I'm going to skip past that one. So this was signed on a Friday evening. So I was, somewhat ironically, back east at a meeting with Democratic Attorneys General as a conference. And so I was on a plane Saturday morning to come back to Seattle. And when I landed, when I turned on my phone, as you can imagine, I had a lot of messages. And the thrust of it was that, hey, there were protests at airports around the country. That was going to be happening at SeaTac Airport, which it did that afternoon. There was going to be a press conference at SeaTac Airport. Governor Jay Inslee was going to be there, members of the congressional delegation. And I was asked if I wanted to be at the press conference as well, which I wanted to be at to express my views on the executive order. But I felt it was more important for me, frankly, to get back home, say hello to my wife and kids, and get to work on examining the executive order and making a determination whether or not we would take any legal action on it. So this is a picture, it was Super Bowl weekend, so this is a picture with a few folks from our team. So I created a civil rights unit in my office back after I got elected. Somewhat surprising to a lot of folks is up until 2013, if you called the AG's office with a civil rights complaint, and we have nearly 600 lawyers, by the way, we do every area of law you can imagine. If you called our office with a civil rights complaint, we referred you somewhere else. We didn't do that kind of work, which struck me as unfortunate. So I created a civil rights unit. The woman you see, she's immediately she's standing next to me, Colleen Melody. She's from Spokane, by the way, and then went to a different law school on the other side of the state, UW Law School, where she was first in her class at UW Law School, worked for the Department of Justice doing civil rights work. And so I stole her away from the Department of Justice to lead a civil rights unit in our office. We've grown that in the last couple of years. So you see Marcia Chen is next to Colleen, and Patricio Marquez is next to Marcia. There are three of the folks who work in that civil rights team. Now, when I created that office, I did not anticipate a case like this going on, right? But it was extraordinarily helpful to have lawyers of this caliber in our office who are experts in this type of law. And the team is impressive. I mean, Marcia is a graduate, I believe, of University of Pennsylvania Law School. Patricio is a graduate of Stanford Law School. I was confident we were in no danger of being out-lawyered in this case if we were to bring it. So those are some of the folks on the team. So our lawsuit, that first weekend, a couple individuals brought lawsuits based on their status and wanted to come into the country. And those are important lawsuits. Our lawsuit, we were the first state to file, and ours was the first challenge to the very constitutionality of the executive order, which is why perhaps it got a fair amount of attention. But we were the first to do it. So that weekend, I could talk all day about that weekend. We were all in the office. Folks are working very hard, and some decisions have to be made on many levels. Are we going to litigate this? Are we not? And so just in terms of the decision making, a lot of people have asked me, hey, Bob, that must have been a really hard decision to file the lawsuit against the president. And I don't mean this at all to be flip, but it really wasn't. I don't want to understate that. I mean, we obviously understood it was a big decision. It was an important decision. There was a lot at stake. But I spoke with Noah Purcell. He's my Solicitor General. He's a native of Washington State as well, by the way. Noah's quite a brilliant lawyer. When I hired him, he was the youngest Solicitor General in the country. I think he was 32. He looks like he's 22. Grew up in Seattle, went to Franklin High School, UW for undergrad, Harvard Law School, edited the Law Review, clerked on the D.C. Circuit, and then clerked for Justice Souter on the U.S. Supreme Court. and was minding his own business, making a lot of money at a private law firm on his way to a partnership track when I stole him away to become the Solicitor General of the state of Washington. He never argued a case before the state Supreme Court, let alone the U.S. Supreme Court. So it was a bit of risk, but I had a lot of confidence in Noah. And one thing I'll emphasize is, the legal team working on this was I think almost all of them, if not all of them, have less than 10 years of experience as lawyers. So for the law students here, I just want you to know that things can't happen quickly in your legal career, right? And I know that, civil procedure can seem like a pain in the ass. I get that. It did for me. But what I want you to know is, look, hey, when we're in court, we are arguing about procedural aspects, right? We are arguing about these seemingly arcane constitutional provisions. We really are, right? And so I just encourage you to keep that in mind, right, when you're in class, that these things will matter greatly to you and the people you are serving or your clients later in your career, and you may be involved in a bigger case sooner than you might otherwise anticipate. So, in talking to Noah about the decision to sue, it really was like 50 conversations we've had about other decisions to bring litigation for the state of Washington. I know that may seem a little strange, but I ask the same questions. I say, first, are Washingtonians being harmed, right? Here we felt that was a pretty easy answer, okay? That was pretty self-evident. The ban had been in place and was harming people in our state significantly. I'd asked about our legal arguments and the strength of our legal arguments. So Noah walked through all those. And I'll show the claims here shortly. He walked through all those. And, we talk about that. My job is to grill him about that, much like your professor's job is to grill you when you're in class, right? So I always ask him to give me a percentage likelihood of success, which is a question he never likes to answer, by the way. He tries to avoid it, but I always try to pin him down. And really at that point, and one more question here was, can I bring that lawsuit? Can the state of Washington bring it? Which is a very important question. Do we have standing? Or is it a claim appropriately brought by individuals who are personally affected, right? That's critical here. Well, if the answers to those questions are yes, people are being harmed, we have good constitutional arguments, we think we have standing, well, doesn't the question answer itself on whether to file the lawsuit? My view is where leaders get into trouble is if they ask questions in making their decision that are not relevant to the answer, to the determination. In other words, what's the governor going to think? What's the legislature going to think? What are the politics of this? You get the idea, right? Those are, I guess, interesting questions, but just so you know, when I'm talking to Noah about this case, those questions did not come up, right? It's about the law. Do we think we have good arguments? Now, look, I'm aware there's, these cases are rarely cut and dried, right? And there's a lot at stake, but those are the questions we're focused on in making that decision. So we decided to move forward. We made a decision to file Monday. So keep in mind, it's now Saturday. The executive order has just been filed, signed, and we're trying to get in court Monday. And the reason is because every hour mattered. Every hour mattered. People being turned away at airports all around the country, every hour mattered. And so the team felt they could get it done by Monday. Now, look, as you will soon discover for the law students here, a filing of this magnitude, right, typically would take you weeks, right? So we were operating on a 3-day time period to get this done. So Sunday morning, for example, everybody was in the office. They were there at 6 in the morning on a Sunday morning. People were working hard. During that weekend, as an example of some of the things we were working through in developing our case, Noah, I think, was the one who suggested that it'd be helpful for us if businesses filed declarations talking about the impacts on their employees and on their businesses. Again, to the issue of standing with the state, bringing this on behalf of the people. So literally, just so you know, on Sunday morning, it was early Sunday morning, 9 or 9:30, I was calling corporate counsel of Amazon, Expedia, and saying, hey, we're filing this thing tomorrow. Are you guys interested in filing a declaration? And to their great credit, I think it was the corporate counsel for one of those companies was watching the game when I called them up. And they moved quickly. They worked through that weekend and had declarations ready to go on Monday. Clients like the University of Washington and Washington State helped out as well. So there were a lot of folks outside of our office who really stepped up and helped our case. And we thought that was important for our case, to show the magnitude of the harm done. We also had, I think the National Security Expert declaration came during the week. So after we filed, the hearing was on Friday. And so we had national security experts file declarations, a bipartisan group of foreign policy experts, including the CIA director for George W. Bush, filed declarations saying that the executive order did more harm to national security than good. So I'm oversimplifying a very complex case, but I want you to get you a sense of, yes, you're a lawyer and you've got to write your brief, but you've also got to think three-dimensionally, right, about making your case and what's going to be important for that judge to see. And we felt it was important that the judge would see, anticipating an argument that national security was at stake, important for the judge to see, hey, there are folks who think this is actually a negative in terms of national security. A lot of folks have asked, why was Washington first to file a lawsuit? It's a question that doesn't have a perfect answer, but a couple things come to mind. Number one, we were not surprised that he signed the executive order. The clip on the Muslim ban during the campaign, I believed him when he said he was going to do it. I believed him. I was under no illusion about that. And so our team was talking about it. Now, we obviously not have the ban in front of us, right? We couldn't see the words until it was adopted. But as a team, we were talking about, hey, if and when this comes out, we knew what team was going to be going to work reviewing that executive order to determine whether or not it was constitutional or not. That's number one. Number two, we had the resources. I touched on that. NOAA, the civil rights team, we had attorneys and professional staff in place who had the background, and frankly, were willing to set aside many long hours to go to work on it. And third, look, I think there is, a decision has to be made, right, whether or not to do it, and the decision had to be made very, very quickly. Sometimes as a lawyer and in life, you don't have all the time you wish you had to make a decision, right? There was no memo for me to make this decision, right? So for example, when we file a consumer protection action, I review all those, I get a memo that outlines the case, and I go through it. There was no time for anyone to put a memo together, right? We're having conversations. And I think for some folks, it was hard to make a decision of that magnitude that quickly, right? I happen to be a believer in calculated risk. I may have even spoken about that here before once with the students, but as just one example is, the dean mentioned I used to play chess a lot. After high school, I didn't go to college right away. I tried to become a professional chess player. It's a very long story. It's not the usual path, as I like to say, to becoming attorney general, but it worked for me, right? So, but in chess, if you'll bear with the analogy, you're playing a chess game and your job is to look at your options and think ahead in your mind to a position in the future. Then you have to evaluate that position and determine whether or not it's good for you or bad for you. I'm oversimplifying, but you get the idea. So I'm saying to myself, I play knight e4, he plays bishop c5, I play rook h6, right? He plays knight c7, and you see a position and you have to decide, is that good for me or bad for me, right? And you look at your different options and you base your decision based on that future position and how it looks to you. Now, the better you get at chess, the better you are at making that evaluation, but no matter how good you get, and I'm confident Magnus Carlsen, the world chess champion, if he was here, he would agree, there are some positions in the future that are so complicated, you can't judge it. You don't know. They're just so complicated, the human mind cannot accurately judge it. And so I discovered in chess there are two kinds of chess players. There are those who are willing to go in those positions, where your risk of win, or your possibility of winning may be higher, but your risk of losing may be more pronounced because you don't know what's going on. There are some players who will go into it and some who will do whatever they can to avoid it. So I would play chess games with folks, and afterwards I'd say, why didn't you play knight e4? And they'd say, well, you did this, that, the other, and that position was too complicated. I didn't know what was going on. And I'd say, well, yeah, but by not playing it, you knew your position was worse. Don't you sort of have to go in there? Like, no, too complicated. Look, I had my weaknesses as a chess player, believe me, but that was not one of them. If I felt that was my best chance for success, right? Okay, that's where I'm going. And in this case, I felt, well, there was a calculated risk. I knew the position for the people I serve was poor if I did nothing. The travel ban's in place, right? So I knew the situation was bad. Yes, is there a risk in bringing this lawsuit? Of course. There's a lot of scrutiny. If the judge rules against us, says we have no standing, kicks us out, it's a bad day at the office, right? There's a lot of explaining to do. But one has to, in the law or in life, embrace calculated risk. And I would encourage you to think that way. Life is uncertain. It is. Who you get married to, what job you take, you name it, right? Life is uncertain, and I think a willingness to take calculated risk, I think, I wouldn't have the job I had unless I was willing to embrace that philosophy. And I think it has served well. So I think that these were some of the factors, I think, for the state of Washington. So here's our case in a nutshell. Now I want to be clear on the original travel ban. Multiple constitutional claims, multiple statutory arguments. I'm going to kind of break them up into two buckets. So number one are constitutional violations, which I spent a bit, we all had to break up our time. I spent a bit more time on these than the statutory claims. We had First Amendment claims and Fifth Amendment claims. So as an example, for the First Amendment, the Establishment Clause, you can't prefer one religion over another, was central to our original claim with the original executive order, the Muslim ban aspect of it, for example. The same with equal protection and due process claims. So these were pretty central and have gotten a lot of attention, of course, in the media coverage of our litigation. There also are statutory violations that we asserted. You see them there. I'll just draw your attention to, I think it's the last one, the Administrative Procedures Act. Look, I'm no expert in APA. Please don't ask me about it, right? I've got a legal team who is. But these may seem relatively arcane. They did not get any press attention. But to give you the example of how important these can be, when President Obama issued his executive order on immigration, which you might recall a couple of years ago, it was challenged by Republican AGs and was struck down by the courts based on the Administrative Procedures Act. That's what struck it down. So these claims can be tremendously important, as you might imagine. So there were many claims that we brought on the original order. Now this picture, this is Monday afternoon, so I had the easy job. I just had to sign the complaint, right? So that's what I'm doing there. The hard job was a team trying to get the complaint to the federal courthouse before the courthouse doors closed. So one newspaper, Reuters, wrote about that. It said, unlike other court papers filed electronically, a paper copy of that motion, right, our complaint, had to be delivered to the clerk's office in person. So Noah Purcell, Solicitor General, led a race to the Seattle courthouse with others from the office. Just as the building was about to close, they pulled up to the courthouse, jumped out of the car, ran up the steps to the doors before they were locked. They arrived just in time. True story. And it was literally that kind of a deal. So, they were literally using every minute they had. It was a very complex filing, multiple declarations. But we really wanted to get in Monday. We thought if we got in by Monday, we'd have a chance to have a hearing that week on Friday, which we did. So, actually, I'm going to go back on this one. So the next day, Tuesday, the judge has a conference with the parties to lay out the schedule. So I think the federal government had to respond like at midnight Wednesday or midnight Thursday, and we had to respond a few hours later with a reply brief. This was, to say it was an accelerated schedule, puts it mildly. And it's hard to describe how intense that week was around the office, but as an example, after that status hearing, I sat down with Noah to talk about the oral argument, which was set for Friday. So keep in mind, this is only going to be the biggest oral argument of somebody's life, right? And so there were three candidates. There's me, there's Noah, and there's Colleen Melody. So those are essentially the three candidates. So I sat down with Noah, as we do for big arguments for the Supreme Court or elsewhere, and I said, well, Noah, hey, I think we can talk about Friday's oral argument. And Noah said, I'll never forget, he said, Bob, that's Thursday's problem. That's how busy things were. The decision of who's going to make the oral argument on this case, that's Thursday's problem. And that was literally, I said, okay, back to work we went. We just had so much on our plate, so many declarations, so many briefs, right? So much was going on that the preparation for the oral argument, even the decision who was going to do it, wasn't going to be made until Thursday. So in the end, Noah was the person who drew the short straw, and he did the oral argument. So here's the judge we got. Western District of Washington, they have a system for randomly choosing a judge. You get, right? Judge Robart was our judge, nominated by President George W. Bush, unanimously confirmed in 2004, a very experienced judge with a reputation for being very fair-minded and thoughtful and very active on the bench, which he was. There's Noah. That's him in court, I think, before Judge Robart. The oral argument was, I think that there's a video of it if you're curious to check it out. I thought the lawyers in the oral argument at the trial court both did a good job. The judge was very active with his questions. And keep in mind, there's very little time to prepare. Noah had one moot court that morning before the decision. So again, we were asking for a restraining order, right? We were asking the judge to issue a nationwide ban that the executive order could not move forward. And a federal judge, of course, has that ability to strike that down nationwide. The standard for getting a temporary restraining order, as you know, is very, very high. One of the standards we have to show is that we are likely to prevail on the merits, which is tough, right? Judges typically want to see discovery and motions for summary judgment and that kind of stuff, right? And especially if you're talking about an act of this magnitude. But Judge Robart agreed with us. And so this is the scene right after the oral argument, just on the courthouse. There was a spontaneous press conference. The guy with the sign, "I'm with Bob," is not an AGO employee, by the way. No state dollars were spent making that sign. It just was a guy who was there. But that's the scene. And, it was interesting. Things became, there was intense interest, of course, by the press once the decision came down. And so I'm always looking for an excuse to put a picture of my mom in my slideshows. So, but I have a good reason. She fits into the narrative. So about 10 minutes after we left the press conference and we all started like checking our phones, and I saw I had a call from my mom. And I assumed she was calling to say, congratulations, right? My mom's 88, about to turn 89. And so I called her back and she said, Bobby, I just got a phone call from CNN. They're trying to find you. So that's when I had some hint, Dean, that life was about to change, right? Yeah, I'm not sure she was aware of quite all what had happened, but CNN was trying to track us down. So the outcome was great. The impacts were immediate. A lot of folks, and I went on Anderson Cooper that night, and they had a panel of folks, and I think even they were taken aback that they had a hard time, frankly, grasping this was going to go into effect immediately. That people could now travel to the country who could not before. That I spent part of that half-hour interview. It was a challenging interview, as you might imagine. It explained that to them. Tens of thousands of travel visas, as you know, that had been revoked, were now essentially reinstated. Green card holders, dual citizens, all could travel. So it was a complete victory for the state of Washington. It was about a week maybe after the decision. We've been so busy, I hadn't had a chance, none of us really had to sort of watch the scenes on TV of families being reunited at the airports, which I think is partly what engendered such a strong response from the public about the litigation. So this gentleman is a Mr. Rabi. He's from Somalia, that's Jay Inslee there, and he was the first individual turned away at SeaTac Airport. He was on his way to Seattle and was turned away when the executive order was signed, and he had come to be reunited with his wife, who was an American citizen. Instead, he was sent back. So this is him now coming into the States as a result of the decision by Judge Robart. And then this individual, he's a dentist from Iran, the gentleman there in the middle, Mr. Novak, and he was traveling to be reunited with his wife, who's a nurse in Silverdale. So he just happened to be at the airport when I was there meeting Mr. Rabi. He was right there, and so we had a chance to chat. But it was a reminder of how the impacts of the executive order were impacting people on, deeply personal ways. And these folks are just a couple of examples of that. So the case went on appeal to the Ninth Circuit, and it went quickly. I should have the dates, but I think we were before the Ninth Circuit. It might have been within a week. It was very, very fast. We had a 3-judge panel. So the quote you see there is from the government's brief, in which they argued that the temporary restraining order, the federal government, Department of Justice, says it contravenes the considered judgment of Congress, that the president should have the unreviewable authority to suspend the admission of any class of aliens. I have bolded those two words for a reason, unreviewable authority. Look, do I concede that the president has broad authority when it comes to issuing executive orders? You bet. Absolutely. That's clear in the case law. But unreviewable authority? Are we not a nation of checks and balances? Do we not have a judiciary? Right? President Obama experienced that, right? His executive order on immigration was struck down by the courts, right? So I was fascinated by that argument, disappointed by it, honestly. But I was curious what they would say at the Ninth Circuit if a judge asked about that. And so the next one, I think I'm going to try and turn the volume up for the next one they asked me to. So let's see. So this is, let me set this up. So this is, I'm not sure if that's working, but this is for the Ninth Circuit. It was available online that people could listen to it. And what you're going to hear is, eventually hear one of the judges asking the lawyer for the Department of Justice the question of whether or not the president's action is unreviewable. So I'm not able to turn this up. I'm not sure if anyone knows that I was told to turn it up. Oh, there we go. I've got it now. Thank you. Yep. Now I've got 78 or so. Sorry about that. So hopefully you'll be able to hear this. So this, again, you'll hear the judge ask that question. Then you'll hear a bit of a pause before the answer comes.
It should be acknowledged that the president is the official that is charged with making those judgments. I'd also like to talk briefly.
Are you arguing then that the president's decision in that regard is unreviewable?
That's the question. Yes. So folks have asked when I was confident we would win. That was the moment. And look, on a more serious note, look, I was proud that Noah, in response, he referred to that argument as frightening at the oral argument. It is. unreviewable? The president's actions, right? Unreviewable? Look, I'm the father of 9-year-old twins. I care about national security, as you might imagine. I'm an attorney general. I care about public safety for my state, but come on, that has never been the law. It cannot be the law. I will not allow it to be the law. But that's what your government, your federal government, is arguing in court. Think about that. Why do we need lawyers, right? It's why you go to law school. I mean, it's not okay. I mean, it makes me mad, right? It makes me mad. They had time to think about that argument. They wouldn't have agreed. Right? Hey, I've argued for the state Supreme Court. You get caught by surprise by a question, not give the answer you really wanted, right? I can understand that, right? This was in their brief. They knew that question was coming. This is the, by the way, for the Ninth Circuit, I should have mentioned this, because it was telephonic, it was a little bit unusual. That was a telephonic argument. And so I was aware that CNN was going to broadcast out essentially live, but Noah did not know that, and we did not tell him. So he had some awareness that was going to be available for folks, but he did not realize if he turned on CNN, there it was, right? And other networks as well. And so what we did was, his office is right next to mine. And so we left him in his office. We just cleared out that whole wing of the office. That whole part of that floor, that part of the office was cleared out. Nobody was there, so he could just focus on his oral argument. So that's Noah right afterwards. So if he looks tired, that's why. And that's Colleen and me. So Noah did a great job, obviously, and we felt good about our chances after the oral argument. Then the decision came out a couple days later. So that's Noah and I reviewing the decision from the Ninth Circuit, which was unanimous. There's a 3-judge panel, 2 appointed by Democratic presidents, 1 appointed by a Republican president, and they completely rejected the president's claims before the Ninth Circuit. Maybe just got a couple more slides. One I just want to mention is, people often write or call, if I'm engaged in something that's high profile. One thing people don't tend to do is write letters. It's sort of a lost art, right? Who writes letters anymore? You'd be amazed the volume of handwritten letters from people in our state and around the country. It's really, it's quite remarkable. These are just some of them, the boxes that we've been getting. And they're, I really should take a quote from one of them. People are really writing in deeply personal ways about why this matters to them, the rule of law, a personal experience. You get the idea. So it's been, it's been kind of fascinating experience on that level as well to see what people have to say. So we had a press conference. There had to be one tweet. Come on, right? There had to be one tweet here. So during the press conference after we prevailed at the Ninth Circuit, I'll never forget this. A reporter said, "Hey Bob, the president has just tweeted." So this is just after we won at the Ninth Circuit, right? And this was the tweet. "See you in court. The security of our nation is at stake." And they asked me to respond, to which I was a little bit puzzled. I mean, because so what I said was, well, we've seen him in court twice, and we're 2 for 2, right? So I wasn't sure if anyone had told him, but I went on to say more seriously, look, what's also at stake is the future of our Constitution, right? That's also at stake. And the good news is that, look, in a courtroom, tweets do not help you, right? It is not the loudest voice that prevails in the courtroom, right? It's the rule of law, right? The Constitution. That's what prevails in the courtroom. And so that's what I found so affirming about the experience on many levels. Despite that tweet, "See you in court," they chose not to appeal to the U.S. Supreme Court. I'll tell you why they didn't. They would have lost. And I don't mean some 4-4 deadlock. Too many people think this was some political calculation by judges. Look, 4 judges had looked at before, 2 appointed by Republicans, 2 appointed by Democrats. They weren't buying what the administration was selling on this one. I have no doubt we would have prevailed by a majority of the justices had they appealed. They chose not to. They ultimately withdrew their appeal, and they actually paid a small amount for our cost of having to file our brief to the Ninth Circuit, which I'm still trying to get a copy of the actual check so I can frame it. Don't quote me on that, all right? That's a joke. That's a joke. A new executive order came out after about a month, which is different in significant respects. The revised executive order no longer applies to green card holders. That's about 500,000 people. No longer applies to folks who have travel visas. That's like 50 to 100,000 people, depending on what numbers you look at. The religious minorities preference, for example, deleted. The permanent ban on Syrians, deleted. So there were many changes, which are a big win. I don't want to that's a big win for us with our litigation. But we still had to take a look at the new executive order to decide if we felt it was unconstitutional. And while yes, there were many changes, I think those are a couple more. Iraq was removed. It did not go into effect immediately. It's delayed 10 days before it goes into effect. Those are all important changes, but if you look at the language of the key provisions, the 90-day travel ban, 6 countries, the 120-day refugee ban, if you look at the language of those, they're virtually identical. So yes, the revised travel ban applies to a more narrow group of individuals, but as you all know, right, whether you're violating the constitutional rights of one person or 1,000 or 10,000, you're violating the Constitution. And so after a couple days thought, we decided to file litigation. That's my last slide. So where things are at now, as you probably know, is we went back before Judge Robart. The good news at this point is now other states were joining. Other entities like the Northwest Immigrant Rights Project were filing their own lawsuits. The AG in Hawaii filed his own. Other states joined Washington. In Maryland, the ACLU filed with some individuals. So there were, in a nutshell, 3 on the same day, the day before the new ban went into effect. There were 3 judges, 3 federal judges hearing basically the same arguments. And literally as we were in court with Judge Robart, the judge in Hawaii ruled and issued the injunction. So Judge Robart has then said he will not rule, which is not surprising, right? The injunction's in place. He does not need to make a decision, so he is not going to make a decision. The judge in Maryland went ahead later that evening or the next morning and also issued an injunction. The Department of Justice is not appealing the Hawaii decision, but is appealing the Maryland decision, so it'll go up to the 4th Circuit. So that's where things stand now. Meanwhile, we do still proceed on the merits on the travel ban before Judge Robart. So the injunction, of course, puts a temporary halt to it until the judge makes a determination on the merits. So that's now happening. We're going to be seeking discovery. We'll be seeking documents from the administration. We'll be seeking depositions, and the team is drawing straws on who gets to depose Rudy Giuliani. So that's all going on. So we look forward to bringing our case and gathering more evidence for our case. So I've probably gone on way too long, but we've got about 20 minutes for questions. And so if you have a question, I guess just raise your hand. I think they have microphones, which will help so everybody can hear. The question. Don't be shy, jump right in.
For those of us who aren't attorneys, could you explain what it means on the merits?
Sure. Yeah, so on the merits, thank you for that question. So on the merits means that there is an injunction stopping it from moving forward, right? But that is by definition temporary until the judge makes an ultimate decision on whether or not the executive order is lawful or not. So what we were seeking was, hey judge, that can take months, right? To go and get documents and put together your motions so the judge can make an ultimate decision. What we can do as lawyers is say, in the meantime, the harm is so great, if this is allowed to go forward, we're asking you to not let it go forward or to stop it from going forward, while you, the judge, can make a decision on whether or not the law is constitutional or not. So that's what I mean by on the merits. What's going to happen is, yes, the executive order cannot be implemented. That's only until the judge, Judge Robart, issues an actual final decision on whether the executive order is lawful or not. And that goes back to why it's hard to get a restraining order. It's hard to get an injunction because you're asking a judge to stop something that's happening, right, until he has time to reach on the merits a final decision on whether something is legal or not. So it's a big ask if you're a lawyer asking that of a judge. So like the case, in other words, the case is continuing on the merits to determine whether or not it's legal or not. But while that's happening, the executive order cannot go forward. Thanks for that question. Yes?
Thank you. My name is Stephanie. I'm a recent graduate of Gonzaga, and I just have a quick question. Following the 3-judge panel's decision, there was kind of an en banc at the Ninth Court, a dissent was authored, and I think 5 judges signed on it.
Yeah.
What I gathered from that dissent was that if the candidate Trump, President Trump, and Mr. Giuliani hadn't made the comments that they made, that it would have been impossible to prove the religious animus behind the executive order, and therefore you couldn't have brought the argument that you brought against it. Kind of the analogy being if President Obama, 6 months ago, had just issued the exact same executive order without making any ancillary comments, it would have been able to fly. Can you comment on that and whether or not you believe that argument has merit? And if you don't have those outside statements to prove the religious animus, how do you ever bring kind of
Sure. Those are important and good questions. So yes, there are, I believe, 25 active judges on the Ninth Circuit. 5 judges concluded, disagreed with the decision not to hear. So 5 of the 25 wrote that opinion. So I guess a couple thoughts. So, I mean, I think what they were getting at was, it was their view that those statements should not be relevant to the decision. So I guess what I would say about that is, look, a document, piece of legislation, an executive order, can, on its face, on the four corners of that document, it can be facially neutral. It can not, when you read it, the executive order does not say, this is a Muslim ban, right? It doesn't say that, right? If you read it, well, okay, it just reads like a normal piece of legislation, right? But courts are empowered to look behind the document to see the motivation for it. And so the standard for us on that claim, so the constitutional claims, the Muslim ban, is we have to show that a motivating factor, not the motivating factor, a motivating factor behind the executive order was essentially a Muslim ban. I'm using that phrase loosely, but you get the idea. Racial animus towards Muslims. That was a motivating factor. So when courts do that, it is entirely appropriate to look at statements made by the principals of who adopted the document. I realize that folks find it, I mean, I get this a lot from the media, right? When I go on CNN, it's like, well, hey, Bob, how can a campaign statement be relevant? I get that it's unusual that the statement is made by a presidential candidate or by administration officials, but in a courtroom on a less high-profile matter, what an executive says, for example, or someone who drafted a document says, is absolutely relevant to the motivation, what goes behind it. So, I mean, to the point, would it be a different case if they never said those things? Sure, right? So I guess I won't speculate, how that would have changed it, but we had many claims that had nothing to do with the Muslim ban, as you saw, right? But that is one that has rightly received a lot of attention. But it's our view that those statements are entirely relevant. And by the way, it's frankly unusual to have that much evidence this early in a proceeding of the motivation behind a document. That's what's unusual. So I got the question from, I think it was Jeff Toobin on CNN saying, well, isn't this unprecedented that a candidate's statements are being used in court? I said, well, yes, but I think it's unprecedented that a presidential candidate said, I'm going to create a Muslim ban, and then did it. That's what's unprecedented here, right? And so, look, if we had a president who said, I'm going to have a Catholic ban, I'm Catholic, I know how I feel about that, right? So yes, I realize it's a high profile, it's an unusual context, but really courts grapple with this all the time, looking behind. That's why we look forward to discovery in our case. Seeking documents, emails. Department of Homeland Security came out not long ago saying that using nation of origin, this is the Department of Homeland Security, put out a document saying using nation of origin for national security purpose is a poor way to do it. So we will be entitled to look behind what information did the administration have for the original or the revised executive order.
If you have questions about me, you can come up there too.
My name is Davis Halston. I am an undergraduate here at Gonzaga University. So my question relates to the religious minorities in these countries getting preference originally under the original travel ban. My understanding is, since the end of World War II, it's been U.S. policy to give preferred status to members of religious minority groups. Therefore, we could avoid situations like the Holocaust and the United States turning away Jewish refugees. So today in the Middle East, when we see radical terrorist groups like ISIS trapping localized Christians, Jews, and other religious minorities on top of hills, shouldn't we still give preference to members of religious minorities since they are most often persecuted and harmed in these regions?
Yeah, I mean, it's whether or not that the challenge is, well, one needs to do these things in a constitutional way, right? And I think it's an example of how weak that was for the Department of Justice, that they took it out of the original executive order when they issued their revised one, right? They had a list of things that they took out, and this was not a part of their oral argument, by the way, this one. So, look, there are ways, each one is, yes, you can say that sounds reasonable, but how one does it, how one crafts it, how one puts it in there is what is the test, right? And in this case, that's literally one that they dropped when they issued their revised order, I think because they realized they had a problem defending that from a constitutional standpoint.
I'm interested in whether or not your efforts to protect immigrants can be extended to some of the heavy-handedness that's going on in regard to our undocumented undocumented residents, and in particular that the state Supreme Court has complained about interference in the state courts, the judicial process, and whether or not the Attorney General's office has any ability to impede the interference that's going on.
Yeah, so I'll try and give a relatively short answer to that question. So yes, where Justice Fairhurst, who's the Chief Justice of the State Supreme Court, recently wrote a letter to the federal government, former Assistant Attorney General, by the way, I should at least point that out, who was now the Supreme Court, Chief Justice of the Supreme Court, and she was expressing, as I understood it, a particular concern around federal agents being around courthouses, where undocumented residents of our state may need to go to court to be a witness, for example, or have legal issues to work out, and you are obviously going to be, if you are, those federal agents may be serving as a deterrent to the administration of justice in our state by being located there. And I think she expressed those thoughts well, and I share those concerns. To the question of our involvement in that, I can't give you a definitive answer right now. What I can say is that we watch these events closely. There have been reports of agents being near Greyhound bus stations, for example, and other locations around the state. Number two is related to that is, a big issue now is welcoming cities or sanctuary cities, right, and counties around our state and around the country. And President Trump has indicated that he intends to issue an executive order that would withhold significant federal funds from any such jurisdiction, right? That's a welcoming city or a sanctuary city. I think that potentially raises legal issues as well. So, what I can say is I've been, I don't want to get ahead of my team, and we have work we're doing, right? But we're very much aware of it. We're having conversations with elected officials around the state from those jurisdictions, and it's possible that down the road we'd have something to say about it more formally. Yep. Thanks.
Attorney General, I was just wondering, you mentioned that one of the reasons you were able to react so quickly to the travel bans, you've done the prep work anticipated this was coming. And so I was just kind of wondering if there are any other areas of President Trump's agenda that you're anticipating where he's preparing in the background to file other suits, et cetera, and what your criteria is for thinking through those issues and what sort of those thresholds are that you're looking at.
Sure. So, I guess a couple of thoughts. So one is, speaking broadly, this is a non-exclusive list, but after the president was elected, we were just giving some internal thought about what kinds of issues we've got certain resources, right? And there are limits to that. Areas of particular interest for me revolve around immigration, civil rights, and the environment. So those are three buckets. It's not an exclusive list, but those are three areas of particular interest. And this one obviously fit within that, the travel ban. Now, in making decisions on whether to sue an administration, look, I don't take that lightly. I twice sued the Obama administration, right, on issues related to Hanford. That's a big decision. It's a big expenditure of resources to do that, right? And so that's another factor for me. Another factor is there are a number of AGs around the country who are supporting us and who have an interest in some of these issues as well. So it may entirely be on the next issue. I may have an intense interest in it, but hey, the AG in New York may be able to take the laboring or leading role, and we can be more in a supporting role, right? That there is a division of resources that we need to consider on this as well. But I would say that those are, in terms of topics, but at the end of the day, it really is, I don't want to oversimplify it, but it is true. I mentioned earlier my checklist. As a harm Washingtonians, do we have good arguments? Can I bring a lawsuit, right? Can I bring it? If the answer to those questions is yes, right, well, then I'm interested. And then you get to resources, or should another state bring it? Or is maybe it's an issue on sanctuary cities, and maybe a city is bringing it, and so we don't have to bring it because it's being litigated by someone else, right? I mean, those are factors that would be going into it. But at a high level, those are the topics that I have a particular interest in.
Yeah, I don't have a question. I'd just like to say thank you for your tenacity and standing up for business.
Just one thing I just will add is, so we have gotten a lot of letters, and I make a promise to only tell one story about my kids, but I've already broken that. talk about Jack. I'm giving you one more, but in the letters back, you know, my 9-year-old twins, they don't obviously know much about what's going on. We largely shield them from that, but you know, they do understand that, hey, the president did something bad and daddy's trying to stop it, is basically what they're writing the story there. And so, but I brought home some of these letters because I was responding to them. And it was interesting that Katie was reading or doing homework nearby, and she saw one of the letters was from a little girl who was writing about her, I think she's 6, and her best friend at school is also 6. And I forget the details, but her best friend's family is caught up in the executive order. And you know, the kid was writing to say how much it meant to her. So for Katie to see that was actually quite fascinating, right? But once she heard about it in those terms, right, a kid that she could relate to. So Katie, what she does now, whenever there's a letter from a kid, she draws a picture on the letter and puts a little note on it from her, which is kind of fun. So that's, yeah, and she's helping out on the responses.
Oh, wow, Dan Morrissey from the faculty again here, and this is actually kind of a follow-up to the very good point the gentleman over there made. I mean, this is extremely impressive work that you do in the public interest at really great financial sacrifice for you and your family. And I think you may have already answered this, but maybe you'd like to go on a little more about what motivates you to, you know, step up and do this wonderful service.
Sure, I mean, I'm happy to. I mean, it's, I guess first, and this is really for the law students here, right, is I am a deep believer in public service, and particularly when it comes to the law, right? There are a lot of lawyers out there, right? And I spent 5 years at a corporate law firm, and my work felt important, right? But it was different, right? The mission of my firm was different than the mission of the AG's office, right? And we need more attorneys, I think, doing public service work. There are lawyers from the ACLU and Northwest Immigrant Rights Project throughout the airports helping folks, right? And it's really inspiring what those folks do. And so for me, that's why I went to law school. My wife, she laughs. I'm not motivated by money at all. The 93 Honda Civic, right? I just don't, money doesn't, I have no interest in it at all. As long as I can pay the bills, so that part of it doesn't bother me, that I'm paid less. What I find is rewarding is public service, being surrounded by colleagues who share that in our office, the mission of public service and serving the people, and the ability to do it with the law degree, I find very, very rewarding. So, you know, it's hard to know why one thinks a certain way, but that's always been my view of the law, and frankly why I went to law school. And look, I get on this issue, look, not everybody agrees with what I'm doing. Believe me, I'm from a large family. I've got 6 siblings. You know, I suspect some of my siblings may not agree with what I'm doing, right? And that's the nature of life and having to make decisions that may not be popular. But I guess for anyone here who, you know, one thing I often hear is a question, well, hey, is this political, Bob? You're a Democrat, Trump's a Republican, that's why you're doing this. To which I say, and I referenced earlier, hey, I twice sued the Obama administration. And believe me, there is no elected official, politician I admire or respect more than Barack Obama. And that's a fact. But did that have any part of my calculation in filing 2 lawsuits against his administration? Hell no. It's not a part of the conversation. It's not a part of it. It can't be, right? I mean, you just have to go where the law takes you. And so it's great to be part of an office where that's our mission, right? And I recognize that, again, my decisions may not always be popular, but I do think it's my job to do those. And I think if you do that in a fair way, people will recognize that.
Thank you.
Yeah, but I do encourage law students. I mean, think about public service with the law. I mean, really, it's there are lots of lawyers. We need more law lawyers in public service, whatever that might be, right? A public defender, whatever you see, right? It's important work. I encourage you to think about it. Where's the next one? Yes.
First I'd like to start off on a more positive note.
Sure.
Commend you for 1723 in support of our state standard workers. I think that's very important.
Absolutely.
My question is regarding constitutional and security challenges here. I'm wondering, would you agree with the general proposition that cases such as you become famous for not only this but the other cases in the past, such as the Baker's case and the Balfour cases? Would you agree with the general proposition that they have caused the Constitution to preempt the Constitution? We're now waging lawsuits based on constitutional grounds to which the defense would be constitutional grounds?
No, if I understand the question, you mentioned, I referenced the Arlene Flowers case, for example, right? I mean, look, I understand the decision, that this is a case, by the way, there's a florist in the Tri-Cities, a man walked in the florist shop. The florist sells wedding flowers. He'd been a long-time customer. He stopped to buy flowers for his upcoming marriage to his longtime same-sex partner, and the florist said, no, I have a religious objection to same-sex marriage, so I will not serve you. We asked her to stop doing that. She declined, so we did bring litigation, and our state Supreme Court, in a 9-0 decision, in a case I personally argued, said that no, that violates our state civil rights statute and consumer protection statutes. And I recognize that my choice in filing that lawsuit, right, is controversial. Believe me, I get that, right? But I just have to say, the result does speak for itself, right? The trial court judge in the Tri-Cities and all 9 members of our state Supreme Court ruled in one way and completely rejected her arguments. And, it's my job is to go where the law takes me, and I feel fortunate so far the courts have agreed with the more controversial decisions I've made. But that's my job, and it's looking for what's worth in that case in particular. No one's requiring any business to provide a certain service. You don't provide a service, you don't have to provide it for someone. But if you provide a service, you must provide it equally. Okay, so you cannot discriminate on the basis of race. We all recognize that. Age, gender, religion. But in Washington State, sexual orientation is a protected class under state law, just like all those other protected classes. It's exactly the same. So in the same way that no restaurant owner can refuse to serve me if I want to have celebrate First Communion with my twins at a restaurant, they can't refuse to serve me because I'm Catholic. You cannot refuse to serve someone because they are gay. You can't. Now, I get that so the disagreement, I think, is in the wrong place. Don't be mad at me for bringing a lawsuit and winning. Change the law. If that's your belief system, change the law. There was a rigorous debate in the state legislature. It was a close vote, but they added sexual orientation as a protected class. My job is to enforce that law, and that's a responsibility I take seriously. For what it's worth, will add, and we'll probably run out of time, is, look, there tends to be, like when I sued President Obama, not one person said that was political. Didn't get a single phone call saying, hey, Bob, you're making a political decision. As Attorney General, I've sued the Washington State Labor Council. I've sued the trial lawyers. If there are 2 bigger supporters of statewide Democratic candidates, someone raise their hand and let me know. I'm serious, right? SEIU, the largest union in the state, sued them. Speaker Frank Chop, Democrat, just wrapped up litigation with him on campaign finance, don't get paid. In the middle of a session in which he's helping write my budget. I'm just saying, right? So I don't get criticized as right. So look, my job is to go where the law takes me. And I cannot stray into any other factor. It just can't be a consideration. So I get those are controversial. I get it angers some of my Democratic friends or folks on the other side of the aisle. But as long as I'm true to that principle, then my views, I think I'll be okay. Do we have time for the last question? Yeah, last question.
I just have a question regarding standing. All those letters that you received from the Washingtonians that it affected them in some way personally, are you able to use those or connect with those people and try to use those as standing?
Yeah, it's a really good question. Actually, I'm not sure if any come from the letter specifically, but definitely we have, and organizations around the state have helped us contact folks who have been personally impacted, where a family member or spouse could not travel, for example. Universities have helped us with students who'd been accepted to colleges or universities who could not travel here, maybe a lecturer who's going to come for a lecture but could not travel from one of those countries. So yes, I can't say definitively came from any one of those letters. Those came after the litigation had gone forward and we prevailed. But the personal stories were a part of our declarations from people all around the state. That's true, yeah. So I guess just to wrap up, first, Dean, thanks so much for having me here. And thanks for all your time. Happy to stick around, and I'll be here in Spokane tomorrow watching the Zags go on to the Final Four.